Hello and welcome to our Freebie Friday video. It's Sade here again. Today I've been asked to cover the rights of a homeowner or subsequent buyers in reference to poorly done construction work on the home. In this situation, we had a former client of ours that discovered that there were leaks in her roof from the original work done by the builder, but she didn't discover this until a lot of years later. At least she didn't know that it was a problem with improperly installed roof. She thought that it was just leaks and normal wear and tear. So what are the rights? Well, the rights of a subsequent buyer, because she was a subsequent buyer, they're essentially the same as the same rights that the original homeowner has. And that's because the buyer steps into the shoes of the original homeowner. So what are the options when you find out that there's a problem with a roof or some other construction work like the foundation and things like that? Well, typically there are two things going on. There might be an issue with the materials, or there might be an issue with the actual work, the way that the work was done. If it's an issue with the materials, or the inspectors that you have tell you that maybe the material itself was the issue, then you'll have an issue with the manufacturer's warranty. If it's an issue with the actual work, the way and the methods used to install or to do the work, then it's a labor warranty issue. Unfortunately, the builders don't give a lot of time on the labor warranty. They warranty the work typically for 1 year or 2 years. So even if they hired a roofing company to do the work, or they hired a foundation company to pour the foundation, the builder is still ultimately responsible to you as the homeowner or the subsequent home buyer. And that's why you file your claims with the builder, unless the documents from the original owner show you that the warranty documents are directly from the roofing company or directly from the foundation company that did the work. So you would just try to figure out what you do have in writing. If you don't have anything else in writing, you go straight to the builder, and then the builder can tell you, oh, the warranty is with so-and-so company that did the work. You go after them. If the warranty period has expired, it doesn't mean that you cannot still file a claim for the improperly done work. So you could still try to file a claim for the improperly done work because you didn't discover the defect until later. So they're called latent defects for that reason, because they're hidden from you. They're not obvious. So you might not find out until after the warranty period has expired that there's an issue with the roof. So you still have a right to go after the builder or the contractor, whoever did the work, for typically a period of 4 years, because that's when you should go after them. Once you know that there's an issue, you should do it within 4 years. In Texas, though, the maximum amount of time that you can go after a contractor for construction work that was done is typically 10 years. Now, you could still send a demand letter in if you like, because you never know, they might actually pay up. But if you've already been past that 10-year period, it's going to be very, very difficult for you to win a case. And so what can you go after them for? You can go after them for breach of contract, or you can go after them for negligence in the work that was done, typically. So those are the main things you go after them for. If you don't want to go through all that hassle and you think that maybe your homeowner's insurance company might actually pay the claim, I always suggest that you file a claim with your homeowner's insurance company anyway, because sometimes, it's a borderline issue with wear and tear, or maybe it was poorly done installation, but then some wear and tear as well. So your homeowner's insurance company might actually pay the claim of replacing the whole roof or whatever the foundation issue is. They might pay that, or they might pay to do the substantial amount of the work. So you don't have to go through all the hassle of trying to track down the builder and file, go through that long process. So try that first, and if that doesn't work, at least you have a report from your homeowner's insurance adjuster saying that this is an issue with poorly done work. This is not an issue with normal wear and tear, or with acts of God like hail storm, or rain damage, or anything like that. And that would actually help you in your argument against the builder or the contractor that did the original work. So you send a demand letter in. If that doesn't work, then you'll have to go through the court system to sue for damages. And that's the quick response to that. I hope this has been helpful in some form or shape. And if you still have other questions, feel free to call or email us, and we'll be happy to cover that, those ones with you directly. All right, and I'll talk to you next time. Happy Friday.